So I specialize in disputes involving wills and trusts, which are typically family disputes. And one of the claims that we see over and over again in our practice is a claim that the person at the time they were signing the will or signing their trust did not understand what they were signing. And what we call that in our the legal field is a mental incapacity claim. So you could envision a scenario where a very elderly person, showing significant signs of dementia, is signing something that they don't genuinely understand. And in those scenarios, the law will actually undo the will or trust that was signed at a time when the individual didn't understand what they were doing. And so, given that the population is aging, unfortunately, Alzheimer's disease is prevalent. We're seeing more and more of these claims as time goes on. The time that the document in question is signed, the precise snapshot in time the document is signed, is critical under Michigan law. And the reason for that is the law recognizes that people have good days and bad days, that people have good hours and bad hours. So you could have, in theory, somebody that lacks mental capacities to sign a will in the morning, but has sufficient mental capacity to sign a will later that day. And so when it comes to gathering evidence to either prove a mental incapacity claim or defend a document, the goal is to get as much evidence of what was going on with the individual's mind at or as near as you can to the time of the will or trust signing. It takes a constellation of facts to prove that somebody lacks mental capacity. So when I'm assessing a potential claim, there are certain common themes or factors I look to try to decide whether I think that there's enough or there will be enough evidence to undo a will or trust that was executed. One factor is, did an attorney draft the document? If an attorney drafted the document, chances are they thought that the person that they were working with had capacity and that they would testify in support of capacity. Was the individual able to carry on a normal conversation with people? Was the individual particularly moody, things like crying spells or severe depression? Was the individual abusing alcohol or drugs or on medication that could have impacted their mental capacity? Was the individual seeing a neurologist or other specialist in cognitive issues? Was there a deviation from the historic estate planning that the client had been engaging in? If, for example, years and years and years, everything was equal to all the children, all of a sudden, late in life, they change and disinherit one child. Personal upkeep, for example, good hygiene. Were they able to independently live, or were they dependent on in-home care, or were they living in a nursing home? Were they able to manage their finances in general? If they're not managing any of their money, would support that perhaps they were not in a position to understand the will or trust that they were signing. Also consider the age of the individual and proximity to death, whether the individual had any physical illnesses, in particular ones that might impact their not only their physical well-being but their mental well-being, whether the individual has already had a stroke. There is some case law that supports that a stroke could be a significant factor in assessing a mental incapacity claim. A stroke, by definition, is brain damage. The question is just how much and whether it's impacting the ability to assess and understand an estate plan. How forgetful the person was. The law is clear that forgetting dates and names here and there is not going to support a mental incapacity claim, but a lot of forgetfulness and close family members or close friends would certainly raise some red flags. Did the individual have bad eyesight or bad hearing that might make it difficult for them to understand the document that they were executing? How complex is the document they're signing? Is it a one-page simple will that's leaving everything to their spouse? Or is it a 60-page document with very confusing, very complex that maybe only a lawyer would understand? The more complex the document is, the more capacity you'd really need to genuinely understand the terms of that document. Capacity is critical because the law allows you to leave your assets to whomever you want. If you want to disinherit your entire family, the law will support you in doing that. However, you have to understand that you're doing that. And so the law requires a certain amount of capacity in order to decide to whom you want your assets to go. And in Michigan, there's a presumption that when you sign a legal document that you do have mental capacity. So it is the burden of the person that wants to challenge the document to come into court with enough evidence to undo the document and prove a lack of capacity.